Tim Lawson-Cruttenden is a solicitor advocate and early in his career a decorated soldier.
There are three reasons, and those are to do with his employment, for compassionate reasons, and to do with his health. And the basic position at the moment is that on receipt of a call-up notice, you've got 7 days to mount an appeal to an army adjudication officer. And if that appeal is accepted, then you don't have to go to this war. I think, though, that the real issue is whether or not there should be a fourth category of conscience. And at the moment, that isn't an admissible reason.
But if you want to introduce a conscience clause, then surely the person shouldn't have joined the TA in the first place, because TA people know they're likely to be called up or could be called up to fight.
Well, of course, I've actually undertaken active service myself, so no one has a difficulty about that. But what they may have a difficulty is having to fight a war which may have dubious legitimacy, both in international law and doesn't have democratic legitimacy, because there's a strong feeling in this country against this particular war, at least at the moment, unless, of course, there's a UN Security Council resolution in its favour.
Is there any precedent that you know of for someone called up to fight? And we're not talking about conscientious objectors in the sense of pacifists. We're talking about people who have fought, who can fight, but who say, no, I like that war, I was prepared to fight that war, but I think legally I don't like this one.
The great precedent has got to be Siegfried Sassoon, who, in the middle of the First World War, actually wrote a letter entitled, "I'm writing this letter in defiance of military authority." And he said,
I believe that this war, upon which I entered as a war of defence and liberation, has now become a war of aggression and conquest. I believe that the purposes for which I and my fellow soldiers entered upon this war should have been so clearly stated as to have made it impossible to change them, and that, had this been done, the objects which actuated us would now be attainable by negotiation. I am not protesting against the conduct of the war.
for that.
But don't members of the armed forces, and indeed reservists, have to obey orders?
Well, I thought we established that at the Nuremberg trials. The principle of the Nuremberg trials was simple, and that is that you only have a duty to obey lawful orders. The issue then is, does a soldier avail himself of defence by saying that he is given a fundamentally unlawful order which he has a duty to disobey? That's the issue.
The unlawful order being an order to go to a war which has not got international legal status.
That's a problem, isn't it? Under domestic law, if the Prime Minister pronounces war, then it is a legitimate war. So I think a soldier's going to be hard pushed at a United Kingdom court-martial to avail himself of defence. However, in international law, there are questions and reservations. And I think if the Prime Minister wants to be intellectually honest about this, and if he accepts that there are people who have reservations, then he ought to give people a conscience clause.